Hello, this is Linda Cheek, and welcome to Using Law Illegally Against Doctors, an evaluation of how the Controlled Substances Act of Title 21 of the United States Code is being used against doctors in complete opposition to the purpose Congress wrote it for. First, a little about myself. I am a physician forced into an early retirement because of the attack on me by the Department of Justice because of pain management. As a natural physician, I could actually justify patients' pain better than conventional doctors. I also helped my patient heal from disease and eventually get off opiates. But that fact didn't matter to the U.S. Attorney's Office, who simply picks an easy target to attack. I was convicted through gross government misconduct and ineffective counsel. During my 28 months of incarceration, I spent many hours combing the law library for my petition for certiorari to the Supreme Court. Through my work, I determined that what the Department of Justice is doing is against the law as it is written. The citizens of this country need to know this. Congress needs to restate the exemption for doctors in terms that even U.S. attorneys can understand. All doctors that have had their lives ruined by this illegal and unethical use of the law should be exonerated and compensated. I would like to draw your attention to my two websites. 7pillarstotalhealth.com is my website about natural healing and alternative medicine. Not able to actually treat people now, I am passing on my knowledge so that you can treat yourself. And doctorsofcourage.org is a website of information pertaining to the attacks on doctors today that treat pain and have found themselves the target of the United States government through no fault of their own except compassion for their patients. Listed are other DVDs that I have created to help people prevent or cure chronic disease. But for once, that's not what I'm talking about today. So let's get started. First, let's look at the justification that the government uses to attack us. That is Title 21 of the United States Code, which is commonly called the Controlled Substance Act. Title 21 is a large statute entitled Food and Drugs, and it covers a gamut of things, including controlled substances. What pertains to this presentation is Chapter 13, Drug Abuse Prevention and Control. You can see this part of Title 21, or the CSA, as the link shown on the DEA website. The CSA was signed into law by Richard Nixon on October 27, 1970. It replaced other older statutes in Title 21 that pertain to illegal drugs. What I have copied here is verbatim from the CSA. But lines that do not apply have been redacted. As you see here, there is no number 1 or letter B. This section shows that findings were written by Congress to justify the bill. Congress's findings show that their purpose in the law was to stem the illegal drug smuggling and trafficking in the country, talking about drug smuggler organizations and narcotics traffickers in other countries. Here, it's referencing borders, air, sea, and land transport. There's no reference to doctors at all. Here, Congress supports appropriations to stop the transport of illegal drugs from outside the U.S., stating that civilian agencies have only stopped a small percentage of drugs coming into the U.S. Well, folks, after 50 years, that fact still hasn't changed. Just think about how much money has been funneled into this bottomless pit, and that's why they've turned their sights on doctors, to fund themselves and their unsuccessful operation. they've taken the focus off the illegal market because they were a failure at it, and turned it on innocent doctors because that has been successful. Here it states the purposes of the CSA: to increase the level of support from the Department of Defense as consistent with the Posse Comitatus Act, which is an act that limits use of military force for interdiction of the narcotics traffickers before such traffickers penetrate the borders of the United States. In other words, the purpose of the CSA is to use every means possible outside of military force to stop illegal drugs from coming into the U.S. To that end, they even established a U.S. Bahamas Drug Interdiction Task Force. In 1986, 16 years after the CSA was signed into law, an amendment was added, which gave the following statistics. Over 500,000 individuals are known heroin addicts. 5 million individuals use cocaine, and at least 7 million individuals regularly use prescription drugs, mostly addictive ones, without medical supervision. $10 million adults and 3 million children and adolescents abuse alcohol. An additional 30 to 40 million people are adversely affected because of close family ties to alcoholics. The total cost of drug abuse to the nation in 1983 was over $60 billion. I'd be curious to know how these statistics compare with today. I bet it's worse, but that is because of the real cause of drug abuse, not prescriptions from doctors. Now, the DEA was created in 1973 to be the governing organization against the illegal trafficking of drugs into the United States, with the U.S. Attorney General as its coordinator. In paragraph 802, we have some definitions. These definitions are actually pro-doctor, giving the doctor credit for knowing what he is doing medically. In my opinion, this is a very important statement because it states that the practitioner determines that there is a legitimate medical purpose for a prescription. Here we start the regulations. First, the Attorney General is obligated to register an applicant that has a license to practice medicine in any state, unless he determines that the issuance of such registration is inconsistent with the public interest. Now, Congress went so far as to delineate what that phrase means, but the DEA misuses this to deny practitioners their certificate, stating that it is inconsistent with the public interest. But usually none of the factors listed by the Congress are involved. They deny it without justification. The factors that are supposed to be used to determine public interest are: 1, that the doctor has effective control against diversion. That would be things like urinary drug screens, pill counts, checking the prescription monitoring program, and also that the doctor is in compliance with applicable state and local law. Then also, prior convictions related to controlled substances could cause a denial. Past experience with controlled substances. But then they have the catch-all phrase, anything else considered relevant to and consistent with public health and safety. But the DEA just uses that last phrase to deny anyone they want, even good doctors, a certificate, even without just cause. Similarly, Congress delineated grounds for denial, revocation, or suspension, such as false statements on the application, conviction of a felony involving controlled substances. If the provider has had his state license suspended, revoked, or denied, or actions that have made his registration inconsistent with public interest. But again, that points to the delineated definitions in the previous statute. And lastly, if the participant has been excluded from Medicare or Medicaid. The DEA must give the practitioner his day in court. When the practitioner gets a denial, he is given the chance to request a show cause for the denial by the DEA. But they use the carte blanche inconsistent with a public interest, so that show cause exercise is a farce. This paragraph is the one used when the DEA walks into a doctor's office and immediately shuts him down, sending potentially thousands of patients to the street for self-treatment. Who decides the prescriptions are an imminent danger to the public health or safety? Is it a medical professional? No. Far from it. Someone in the DOJ with no medical background or training, whatever. Okay, now we get into the statutes about how prescriptions can be dispensed. Schedule 2 prescriptions must be written except in an emergency. Schedule 3 and 4 prescriptions can be written or oral. Schedule 5 can also be written or oral, but they make this, in my opinion, unnecessary statement that they must be for medical purpose only. I don't know of any doctor that does not know this and adhere to it to the letter. This paragraph is talking about prescriptions being furnished through telemedicine. The points of this statute are that 1. A prescription just be dispensed with a valid prescription which is issued for a legitimate medical purpose, which, remember, is determined by the physician in his professional practice. 2. The practitioner only has to conduct one inpatient medical evaluation, which can also be done by a covering practitioner. So based on this, how can they now be charging doctors with failure to have a physical exam on every visit? I take some issue with paragraph 2 here. But in the same token, it could prove useful in court. This makes absolutely no sense under the general provisions of the law written in 1970, which gave the physician the express authority of determining the legitimate medical purpose for a prescription. I would use this phrase actually to state that absence of physical signs does not eliminate the need for a prescription, since usually the determination of pain is subjective and by history, not by physical exam. This paragraph states that only one in-person medical evaluation is required with telemedicine every 24 months. A physical exam can only be conducted in a person visit. If a physical exam is not necessary every visit for a telemedicine evaluation, why isn't that also true with an in-house evaluation? Now we are moving on to offenses and penalties. Under this statute, it is unlawful to distribute controlled substances or counterfeit substances except as authorized. But this demonstrates that the purpose of this act is to cover illegal dealing, because doctors are authorized. Look at these penalties: 10 to 20 years without possibility of parole, with fines of $10 million to $50 million. This again proves that the law is targeting drug cartels and illegal markets, not doctors' offices. For Schedule 3, like Lortab or Vicodin, it's 10 to 15 years without possibility of parole, and fines of $0.5 to $2.5 million. For Schedule 4, like benzodiazepines, it's 5 to 10 years and up to $1 million fine. Again, they aren't referring here to doctors. And finally, Schedule 5 gets 1 year and up to $250,000 fine. You see, drug cartel money was supposed to help fund the DOJ, but they found out that that wasn't as easy as they thought it would be, so they turned to doctors instead. There has never been any love lost between the two professions of law and medicine, but really? Again, this shows proof of targeting the illegal drugs, not prescriptions. Distribution at truck stops or rest areas? Have you ever heard of a doctor's office at a truck stop or a rest area? Or involving treaties and international agreements? Is Doctors Without Borders going to be on their list of targets next? Even the criminal forfeiture statute shows that the target is the drug cartels. But this statute is the reason they turned the law against doctors. You see, it's a lot easier to prosecute doctors than it is the cartels. And there are a lot more of us. What they can't get in amount, they can get with quantity of attacks. And that's just what they are doing. Again, just the penalty here shows for maintaining a drug-involved premise shows that the actual target is not doctors, but illegal distributors. More evidence that the focus of the law is illegal drugs shows them listing endangering human life while illegally manufacturing, distribution to persons under 21, distribution or manufacturing near schools or colleges, and specific sentencing for methamphetamine around children. Now I want to show you the United States Sentencing Commission's drug quantity table. This is what is used to determine the sentence for a drug felony. Notice the amounts of drugs that are listed. This is definitely at the level of illegal drug distribution, not doctors' prescriptions. The heaviest sentence listed is level 38, which only lists Schedule 1 or 2 illegal drugs. In order to use the sentencing guidelines against doctors, all drugs are converted to an equivalent of marijuana. That is to make all drugs fit the, quote, crime, unquote, of the Controlled Substance Act, which only lists illegal drugs. In my opinion, this is another illegal use of the CSA, and not what Congress intended. They listed illegal drugs for a reason, because the law is designed to fight illegal distribution, not legal prescribing. In order to charge doctors with a crime, the milligrams of medications are converted to their equivalents of marijuana for sentencing. I don't know about you, but I don't appreciate my legitimate work being equated to an illegal drug. So here are the drug equivalencies for Schedule 1 and 2. What's wrong with this picture? Are doctors classified as drug dealers in this law? No, they're not. Here is the first time Schedule 2 prescription drugs are mentioned with unlawful possession, not distribution or dispensing in the sense of a doctor's prescription. In order to confiscate more assets and get higher sentences, doctors are now being charged with racketeering. But look how racketeering is described in the amendment to this act from 1987. Again, this is prior to the starting of the attacks on doctors. And again, this was designed to go after the drug cartels. So here it describes what is involved with racketeering. Unlawful conduct of racketeer, influenced, and corrupt organizations. Again, the drug cartels. Interstate or foreign travel, or transportation in aid of a racketeering enterprise. Again, businesses that are outside of the United States. And 3, violent crimes in aid of racketeering activity, which is the type of activity that you see with the drug cartels, not doctors' offices. Murder for hire. And finally, using extortion to collect a debt. How are they ever getting racketeering charges against doctors using this law? They are doing it based on complete blindness of the American people in the courtroom. None of this has to do with running a medical practice. Now I want to discuss how the government attacks are violating our constitutional rights. This is an area that defense attorneys should be pointing out to juries. These are the rights that are being violated. The Fourth Amendment right of unreasonable search and seizures. This is what brings the government into the doctor's office in the first place. You see, they don't come in with actual crimes having been committed. They come in with a search and seizure warrant that covers everything, and then they create the case based on what they accumulate. The Fifth Amendment right of due process of law pertains to federal law. The Sixth Amendment of an impartial jury and having assistance of counsel for his defense. With government propaganda, there is no such thing as an impartial jury anymore in this country pertaining to opioid use. And having assistance of counsel when everything the doctor owns is taken away from him as in a forfeiture, then he has no way of defending himself. And then the 14th Amendment is depriving a person of liberty or property without due process pertaining to state law. We will also be getting into the case law and looking at our rights there and how they're being violated. Case law is that which is created through the court system. In U.S. versus Roth, it was stated that deliberate perjury to the grand jury may result in dismissal of charges. Well, perjury by government agents to the grand jury is basically what gets doctors indicted in the first place. In U.S. versus Rosselli, this pertains to outrageous government conduct and states, quote, "The acts of the government have violated the consensus and exceeded the limit of what a free society can tolerate." And basically this is what's going on in the court systems today. That's pretty much all they do now. And they get away with it because no one points it out to the jury. Linder versus U.S. is an important case pertaining to the control of medical practice. It states, quote, "Direct control of medical practice is beyond the power of the federal government. Congress therefore cannot directly restrict the professional judgment of the physician or interfere with its free exercise in the treatment of disease." Well, that statement in and of itself, by itself, should negate all these attacks on doctors, because doctors are no longer free to practice medicine in the area of pain management. Again, back to Linder versus U.S. Federal power is delegated, and its prescribed limits must not be transcended, even though the end seems desirable. Congress cannot, under the pretext of executing delegated powers, pass laws for the accomplishment of objectives not entrusted to the federal government. Any provision of an act of Congress solely to the achievement of something plainly within the power reserved to the states is invalid and cannot be enforced. Obviously, direct control of medical practice in the states is beyond the power of the federal government. So again, this proves that the Controlled Substance Act is pertaining only to illegal drugs, not medical care, because by law, medical care is not under the jurisdiction of the federal government. How then have they been able to get away with this for 15 years if it's not legal? Because no one in the law profession wants to stop the gravy train. Defense attorneys are making a killing at it too. Ethics is no longer a factor in the legal profession. Continuing in Linder versus U.S., it said that the law does not undertake to prescribe methods for medical treatment. Quote, "We cannot possibly conclude that a physician acted improperly or unwisely or for other than medical purposes solely because he has dispensed in the ordinary course and in good faith. What constitutes bona fide medical practice must be determined upon consideration of evidence and attending circumstances." So how can they say that a prescription was not for a legitimate purpose when given to a patient during a medical visit? Heyman versus Galveston states that the right to practice is liberty and property within the meaning of the 14th Amendment to the Constitution. And yet we, as doctors, are being denied that right, and our property is being forfeited illegally through this act. It continues in Gonzalez versus Oregon to say, quote, "The statute and our case law amply support the conclusion that Congress regulates medical practice insofar as it bars doctors from using their prescription writing powers as a means to engage in illicit drug dealing and trafficking as conventionally understood. And that does not mean giving a patient that comes to the office complaining of pain a prescription for that pain. It's talking about actual street drug dealing." According to Sorrells versus U.S., the government cannot incite an illegal act. The criminal acts in Sorrells versus U.S. were, quote, "creature of the agent's purpose," unquote. The court called the action a gross abuse of authority. Chief Justice Hughes concluded that to provide the opportunity to commit the crime is beyond reproach. The government may not incite or create crime for the purpose of punishing it. It is unconscionable, contrary to public policy, and to the established law of the land to punish a man for the commission of offense of the like of which he had never been guilty of if the officers of the law had not inspired, incited, persuaded, and lured him to attempt to commit it. Now, the DEA's confidential sources are doing just that. They come in, incite an action on the doctor's part, and then accuse him of a crime. And the doctor isn't even aware of it, because they do complain of pain, and the doctor prescribes them according to the history, and then the doctor is charged with committing a crime. This is a crime incited by a government agent and should be disallowed in the court. In Boyd versus U.S., the court stated that, quote, "the disputed question is whether the defendant issued the scripts in good faith in the course of his professional practice." The court instructed the jury that if they were issued in good faith for the purpose of curing disease or relieving suffering, the defendant should be acquitted. In Jin Fui Moy versus U.S., it states, quote, manifestly the phrases "to a patient" and "in the course of his professional practice only" are intended to confine the immunity of a registered physician in dispensing narcotic drugs strictly within the bounds of professional practice, and not to extend it to include a sale to a dealer or a distribution intended to cater to the craving of an addict. Now, the government has actually taken this phrase, which actually supports doctors and their prescribing, and has completely misused it in court. Prosecutors should not be allowed to fabricate and lie on a request for a search warrant. This is a violation of the person's 14th Amendment rights. By this flagrant abuse of authority, the government can invade the private domain of anyone in this country that they choose. When they stop going after doctors, could the next profession be yours? This has to stop. This breeds anarchy. As a victim of this type of outrageous government conduct, I am working toward informing the entire country of this rampant abuse of power. Please pass the word through purchase of this DVD. I appreciate any contributions of any other case law. I also appreciate any monetary contributions to help get the word out. For donations, you can go to the website listed below. It's on 7pillarstotalhealth.com. Then you can also backtrack to the DVD section of the shopping cart to purchase the DVD. Thank you for your time, attention, and service to get this information spread.